What is this matter pertaining to?
Lordship, non-payment of contextual bill amount, Lordship.
Mm.
In this regard, we have filed our affidavit, Lordship.
What is your stand?
Lord, they had not completed the entire work, Lordship. Kindly peruse affidavit in opposition, Lordship, paragraph 4, Lordship.
None appears on behalf of the petitioner on call. Mr. P. Bodlow appears on behalf of the respondent numbers
2, 3, Lordship.
2 and 3. The petitioner herein has approached this court claiming an amount of rupees 1 crore 9 lakhs 39,301 against the work completed by the petitioner pertaining to the work order dated 6/8/2007, along with interest at the rate of 18% per annum. Pursuant to the filing of the instant writ petition, the respondent numbers 2 and 3 had filed an affidavit in opposition. In the said affidavit in opposition, the set stand of the respondents is that the respondents have the said respondents have till date paid an amount of rupees 151,96,725 till March 2017. It was also mentioned that the petitioner would have been entitled to an amount of rupees 282,21,765 at the end of 5 years from the date of completion of the installation of the system under the project. However, the petitioner have not completed the project and have also not carried out the not undertaken any mandated period maintenance, that is CMC. It is therefore stated that the petitioner is not entitled to the amount taking into account the stand of the petitioner, of the respondent number 2 and 3, it therefore appears that there are serious disputed questions of facts which requires adjudication in a forum wherein evidence can be led. Under such circumstances, this court is therefore not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution. Accordingly, the instant writ petition therefore stands dismissed. Liberty, however, is given to the petitioner to approach the appropriate, to approach the competent forum wherein evidence can be adduced for resolution of the disputed questions of facts. This court further, taking into account that the petitioner have been bona fidely pursuing the instant proceedings, observes that the period from 31/1/2018 till date be excluded while computing the period of limitation. Obliged.
It will be working. If you have item number 4, the methodology is infructuous. Methodology become infructuous.
Mr. M.K. Chaudhary, the Learned Senior Counsel, assisted by so-and-so, submits that the writ petition has become infructuous.
On behalf of Water Resource.
Ms. So-and-so appears on behalf of the Water Resource Department. Taking into account the above, comma, the instant writ petition therefore stands closed as it has become infructuous. Interim order, if any, stands vacated. What about the other one? Here also you are appearing. R. Sharma, some R. Sharma is appearing. What is the matter about?
It is same from professional.
Same.
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 দুইটা infraction. দুইটা সেম কথা বলছি সেম কেস মানে
He says, well, same thing. But there is a-
Okay, here we dismiss it for default then. None appears on behalf of the petitioner on call. Full stop. On the other hand, Ms. So-and-so appearing on behalf of the Water Resource Department submits that the instant writ petition has already become infructuous. Why?
Because the contract was of 2016-17, contract period is over.
In view of the fact that the contract in question was for the period from 2016 and 17, and nothing further remains in the instant proceedings. Taking into account the above, this court therefore, it therefore appears that the petitioner have lost interest in the instant proceedings. Accordingly, the writ petition therefore stands dismissed for non-prosecution. Yes, what is this?
The fair price license, my lord, cancel, my lord. After so inquiry, my lord. And appeal was also dismissed, my lord.
Hmm?
Till appeal was also dismissed, my lord, statutory appeal, my lord.
None appears on behalf of the petitioner on call. Mr. B. Bukel appears on behalf of the respondents. The petitioner herein have approached this court challenging the order dated 29/2017 passed by the District Commissioner, Kamrup Lower Assam Division, whereby the appeal filed by the petitioner
Yes.
was dismissed. And further, also seeking direction that a license bearing number APDAO /RL/GAU/A/77 in the name of the petitioner be reissued. It is seen that this court, pursuant to filing of the instant writ petition, had issued notice. Almost 7 years have passed by. Further to that, it is also seen that an affidavit in opposition has also been filed by the Deputy Commissioner Kamrup on 9/6/2023, whereby detailing out the reasons as to why the petitioner's license was cancelled and the appeal was dismissed. Full stop. Taking into account the above, so it is also seen that the petitioner thereupon have not chosen to file any reply. It therefore appears that the petitioner have lost interest in the instant proceedings. Consequently, this court therefore dismisses the instant application for non-prosecution.
Obliged, my lord.
The matter relates to pending bill for food, supplying food items and refreshment lordship in the Panchayat election 2018 lordship.
What?
On last occasion,
You supplied lunch
lordship.
and now you're not getting the money. Why you are not being paid? Have they filed affidavit? What is their stand? Affidavit, what is their stand of the affidavit?
Two occasions,
Who has filed the affidavit?
state election,
What is he? Assam State Election Commission. What do they say?
the affidavit lordship, it was stated that it has been sent the Panchayat. Okay.
How much you are entitled to?
7,200.
Who is appearing for the PNRD? PNRD is the main person.
On last,
No PNRD. Yes, Assam State Election Commission is also not representing. PNRD is also not there. And what is the stand of the Deputy Commissioner?
Lordship here. 17,13,200 is a remain outstanding. Paragraph check. My lord, may kindly peruse the paragraph second, Lordship. Paragraph 2, Lordship. Paragraph 2, Lordship. তাহলে এখানে ফেলবো না কিন্তু। পঞ্চায়েতে ফেলবো না আমি। পঞ্চায়েতে ফেলবো না।
You filed this by way of an affidavit.
Lordship.
Then we take it up with the PNRD.
Lordship.
Mr. K. Gogoi appearing on behalf of the District Commissioner,
Lordship.
Dhemaji, I placed before this court a set of instructions issued by the, a communication issued by the Deputy Commissioner Dhemaji, District Commissioner Dhemaji, dated 3/12/2021, wherein there is a clear-cut admission that that an amount of rupees 17,13,200 has remained outstanding towards the petitioner. Full stop. Taking into account that the said instruction is of the year, the said communication is kept on record and marked with the letter X. Taking into account that the said instruction is of the year 2021, it is the opinion of this court that the said be brought on record by an affidavit be filed on behalf of the District Commissioner Dhemaji, giving up-to-date status of the claim of the petitioner. Full stop. This court I have also taken note of that none has appeared on behalf of the PNRD department when the matter is called. Full stop. Considering the above, this court fixes this matter on 4th of February 2026. The District Commissioner Dhemaji is directed to bring on record the affidavit on or before 2nd of February 2026. It is further observed that if the PNRD department is not represented on the next date, this court would be compelled to pass appropriate direction for the personal appearance of the officer concerned.
Resolution.
Yes, what is this Assam Power Distribution Company doing? Let us dismiss their case today. What is this? They are filing all these cases. Copy of the meter. Mr. Kegugoi, tell me, if an order is being passed by the Consumer Redressal Forum,
Lordship.
why should this court exercise jurisdiction?
Then they have to lordship.
Huh?
Approve the proper form for execution of the order also.
Fellow, none appears on behalf of the APDCL on call. It is also seen that the respondent is also not represented. For the ends of justice, this court adjourns the matter to be listed on 16th of February 2026. It is observed that if none appears on behalf of the APDCL or on behalf of the petitioners on the next date, this court would be constrained to pass if none appears on behalf of the petitioner on the next date, it shall be presumed that the petitioner have lost interest in the proceedings accordingly. List accordingly.
Close yours.
Yes, please, your lordship. Lordship, item 7, I was not, I was on legs. So,
Why have you not made the payment?
Lordship, we have already communicated with the DC, Dhamaji. We have already communicated with the DC for, submission of bills.
Why no affidavit is filed?
Lordship, kindly, more time may be given. We will file our affidavit.
More time is 2 o'clock?
Lordship,
No, it can't go like this.
2 weeks time.
First of all, you stop holding these elections if you don't have money.
Yes.
If you don't have the money, resources, don't hold. Although it is a constitutional duty for you to hold the elections. And if you hold the elections, tell your officers concerned, don't have tea, coffee, anything. Ask them to get their own tiffin. But if you ask them to hold it, then you are also being bound to make the payment. It can't go for a period of 7 years. I'm putting in non-appearance. The reason is very specific. Let these people come and don't appear on the next date. Then we call that particular person the commissioner. This is not done. In the meantime, if you can do something, if this matter by any chance again comes back to me, bad day again. But you stop holding elections if you don't have money. Or tell them that issue an office memorandum. You see, we don't have money. Bring your own flasks of tea. Bring your own tiffin. And you have to start the morning at 6 o'clock and end at the 7 o'clock in the evening. But we are not in a position to pay. The PNRD department is defunct. The reason being, in auction process, when we sell out, we give it to the lowest bidder, not even to the highest bidder. Come up. Take up some stand like that. This is what is happening in PNRD. You give it to the lowest bidder. The reason is, whatever may be, money is different. We don't need money. But you don't have the money to pay to those persons who have supplied the refreshments. So, order remains as it is. Next. Yes, who is appearing for item number 9?
And for the agriculture department, it is for establishment of a small nursery lordship. We have filed our affidavit lordship.
Small
Nursery lordship.
nursery.
Yes, lordship.
Where?
In Kachar district lordship, we have filed our affidavit on 28th of June 2022. Lordship, on a joint verification, they have not yet established the nursery lordship. We have annexed the photographs also.
They have not done.
No. Nothing lordship. So the subsidy amount only in completion, we would have paid them lordship.
Nursery, what they oh, they have put a photograph. Amin nursery.
Lordship.
Huh? That's
Annex
one.
3 of my affidavit lordship, we have given a photograph.
Huh?
They have not yet
So
established
nursery
the
means
nursery lordship.
what type of nursery should it be? It should be something with built houses.
Lordship in paragraph 5 of my affidavit lordship.
Huh? That a small nursery was sanctioned to the petitioner. By the sanction order, accordingly, the petitioner requested the respondent to submit up-to-date status report of the area with photographs. Prior to payment of the bill will be following information.
Paragraph 5, lordship, mother block of fruit plants. we have-
Al-Amin Nursery. The personal visit to the said nursery and the same has been forwarded to the deponent to either so-and-so alleged he submitted the following: mother blocks of fruit plants at least 2 bighas, irrigation facility with overhead tank, greenhouse so-and-so, not notice, garden implements like hoe, so you have rejected it.
Lordship.
Okay, we give him another chance. None appears on behalf of the petitioner on call. On the other hand, Ms. So-and-so appears on behalf of the Agricultural Department
The respondent.
and submits that the petitioner herein is not entitled to any subsidy in view of the fact that when an inspection was carried out, the petitioner there was nothing found, thereby entitling the petitioner to the subsidy as claimed. In that regard, the learned counsel has referred to paragraph number 4 and 5 of the affidavit in opposition. It is also seen that the said affidavit in opposition was filed on 29/7/2022, and the petitioner thereupon have not filed any reply. Full stop. It therefore appears that the petitioner have nothing to say as regards the stand taken by the respondent. Be that as it may, for the ends of justice, this court adjourns the matter today to be listed again on 21st of January 2026. It is observed that if no reply is being filed on or before the next date, it shall be presumed that the petitioner have duly accepted the inspection report and thereupon necessary order would be passed.
Obliged.
His lordship, I'm on behalf of the respondent BTC lordship. This writ petition is in connection with cancellation of the fair price dealership of the petitioner.
Fair price.
Yes, your lordship. And the
Fair
state-
price shop you have cancelled.
Your lordship, we have revoked, initially we had suspended and revoked, but thereafter lordship, again complaints from the consumers came in. And for that purpose, the order was modified to the extent that the consumers of the fair price petitioner were tagged with another fair price shop. And to that effect, lordship, they had come before this honorable court.
Now what is the present status? Is he running?
No, lordship. We filed our affidavit lordship in this case.
Or it's against the non-renewal?
On
How can you not renew?
Lordship, because that was, the inquiry was still going on at that point of time.
Wouldn't that amount to cancellation? Normally, renewal is the norm. And non-renewal amounts to, is to be done in extreme cases.
Lordship,
Against the non-renewal, he has come.
Lordship. Your Lordship, but kindly peruse the show cause notice we had issued. That is at Annexure C. page-
Understood, but Shoko's notice is no longer there because you have dropped those proceedings.
No, thereafter, Lordship, that proceedings, after that, there was an amendment to the said, we passed an order to that effect. Lordship, that is on 29th May 2018.
Page
Annexure D, page 81 of our affidavit, Lordship.
82.
Page 81, Lordship, Annexure D. If I may read, Lordship.
Yes.
Peruse the report dated 28/5/2018 submitted by the Inquiry Officer of Food Civil Supplies and Consumer Affairs, Kokrajhar, regarding public complaint filed by Mohammed Jan Mohammed Mondal and others in the matter of lifting and distribution of PDS, TPDS commodities by the agent, namely the petitioner, Lordship, under Kotgaon SS Limited. It appears that the agent Mohammed Alkash Ali SK had violated the certain provisions of APDA and Order 1982, for which allocation of commodities in the name of the petitioner was suspended from February 2018 till April 2018, and subsequently arranged to distribute the allocated quota of PDS.
So this is okay. So
But-
therefore you are allowing him to run.
Lordship,
Are you not?
yes, your Lordship. But only aspect is that, Lordship, his consumers were tagged with the other fair price.
No, you see, the last paragraph, keeping in view all aspects, including avoidance of dislocation of so-and-so,
Lordship,
so-and-so is temporarily allowed to distribute the allocated quota
Lordship,
in respect to FP shop of so-and-so among the bona fide iman in presence of so-and-so. So you have given it to whom?
it was given to Lordship.
So you have allocated that to somebody else.
Lordship.
No, that's okay. I'm not on that. But are you therefore not cancelling it without following the procedures under 15(2)?
The cancellation, we haven't cancelled it, Lordship.
Huh?
We haven't cancelled it, Lordship.
You have not cancelled it, but you have not renewed it. Very funny. You are for BTC?
BTC, Lordship.
Yes, Mr. Bukel, the expert in fair price shops. Yes.
It also was the exactly same putting lordship.
Now, understood.
Lord.
You see, normally a license is valid from time to time.
Lordship.
Renewal is a norm.
Lordship.
Exception is very, very exceptional is non-renewal. You can very well cancel it if there is a violation to the license or the order. For that, you need to exercise powers under clause 15.
Lordship.
You don't do that. You wait, period is over, you don't renew it. If you don't renew it, isn't it also your incumbent, your duty to apprise him why you are not renewing it? Taking into account that you are taking away his right to continue with the fair price shop.
Reason behind this lordship, we have stated in our affidavit lordship. One police case is pending before the Kokrajhar PS case, lordship. And
So,
in
isn't
2000
it your very stand which had been taken out of on that earlier matter? Yeah, on Friday when I was taking up that matter,
Lordship.
isn't it your very stand that when an FIR is being filed or a trial is being going on, the Food and Civil Supplies Department or the district administration just pulls their hand, they don't look into that. Isn't that your stand there?
That day lordship,
Huh?
that day lordship, this was the stand of the lordship that
That is why I asked you. That is why I asked Miss Yudas on that date. Are you going to stick to this stand? Because if you stick to this stand, these are the problems which are going to ensure.
Yeah, lordship, in 2022, we have filed affidavit lordship. That at that time, lordship, the case was in the initial preliminary stage, nation stage lordship. At that relevant point of time. If lordship permit, I can obtain instruction regarding present status also lordship.
Now, my question is,
Lordship,
when it is an exception,
Lordship,
you
Lordship.
have to give due reasons.
Hmm.
If it is not an exception,
Lordship.
yes, you may not extend it,
Lordship,
but it is normally done.
Lordship, Lordship.
Then you have to give due reasons
Lots-
as to
lots.
why you are not
There
extending
should
it.
be a reason order, Lordship, there.
Okay. The petitioner herein has approached this court being aggrieved by the non-renewal of the license, the fair price shop license. Full stop. This court have duly perused the affidavit filed by the respondent number. For why the respondent number 4 is filing two affidavits?
See,
No, who is the respondent number?
in our report, Lordship, only one affidavit is there.
The affidavit filed by the respondent numbers. Respondent number 2. Respondent number 2 and respondent number 4. Wherein they mentioned that on account of certain pendency of certain criminal proceedings, the license have not been renewed. This court have duly perused the Assam Public Distribution Order 1982, as well as the license which have been issued in terms with the enclosure to the said order of 1982. From perusal of the order of 1980, provisions of the order of 1982, as well as the covenants contained in the license, it is seen that the license in question, the renewal of the license is a norm and non-renewal is an exception. Under such circumstances, this court inquired with the learned counsels who represents the respondent number 2 and respondent number 4 as to whether it would be fair and reasonable on the part of the respondent authorities not to renew by not disclosing the reasons. First, Mr. K. Gogoi as well as Mr. So-and-so who represents the concerned respondents submits that they would obtain necessary instructions to list this matter on 16th of February 2026 for an update.
Eligible.
Yes, Mr. Counsel, I have not seen you for a long time. You don't do matters in bench 4. This seems to be some bench 5 matter. You're a specialist in bench 5. Some compensation business. Or what? Outstanding, okay.
Content of the outstanding bill, my lord, page 7 is the work completion certificate, my lord. Page
Yes,
7,
have you got the money?
but,
Yes, who is paying for NHRM? Mr. B. Gogoi. Huh?
one of my colleague is appearing on.
You obtain your instructions.
Lordship.
This is the affidavit file. The old matter, 2023 non-payment is too old.
Lordship.
Okay, we have it in the 4th week of January.
Right.
Obtain your instructions. Yeah, you got your instructions.
Already it has been paid.
He has got the money.
Paid to the district, my lord. We maybe received the payment.
When did you pay?
District,
Give us the instruction.
no.
Then why are you making the submission?
Instruction is,
Huh?
I have just received the telephonic instruction. This is
You won't do.
earlier district, earlier instruction.
Earlier instruction is old. Okay. So you get your written instructions.
Yes, my lord. Next date I'll.
This was old one. This
Yes,
was what
ma'am.
you have shown.
Today I have received on telephone instruction.
Because this was in the month of January.
Yes,
We are in the month of December, and we are going to have this within this year. And it has to finish off. We'll have it on 19th.
yes,
If not paid, pay.
yes.
Okay, list this matter. On 27/1/2025, it was informed to this court that the bill of the petitioner is duly admitted and it is it is being processed. Full stop. Almost 12 months therefrom, the matter has been listed today. Full stop. This court inquired with Ms. A. Bora, the learned standing counsel of the NRHM, as to the status, as to whether the petitioner had been duly made the payment. Full stop. She submits that she would obtain instructions. Full stop. Taking into account the above, lists the matter on 19/12/2025. Mr. Appearing on behalf of the petitioner shall also apprise this court as to whether the petitioner has received the amount. Yes, A to Z. A to Z is where? What is this case of A to Z? Hey, শুনকচোন। এইটো যে ইমানটোক চিনিয়ৰ এডভোকেট বনাইছে কেতিয়া? হাইকোৰ্টে বনাইছে নে ৰেজিষ্ট্ৰি অৰ্ডাৰ সুধিবচোন ৰেজিষ্ট্ৰি তাহাঁতি দিয়ে নেকি? হা তাহাঁতকে দিব কালিৰ পৰা আমাৰ চিনিয়ৰ এডভোকেট ৰুলখন বদলাই দিওঁ তাহাঁতক কম। What is this?
Sir, about payment, non-payment of contractors bill, my lord. The work order was of 2004, my lord.
My goodness.
My lord, this was at the time of Cotton College. It was at the time of Cotton College, my lord, for construction of, my lord, girls' hostel walls and of Cotton College. My lord, I represent the university, my lord. The university came into existence, the present one in 2017. Prior to that, the Cotton College State University was, came into existence in 2011, my lord, at which time Cotton College was also there. So we are there from 2017. But we do not have any records. The petitioner has also enclosed our communication to the DHP at page 152.
Payment of what amount?
3,77,000.
That is okay. Where? Period work order of so and so. He's lucky enough to get a notice.
Question of maintainability we had raised, my lord.
Hello.
An order was there, my lord.
Why nobody is appearing?
The order dated 11th August 2023, my lord.
No, we cannot direct for making verification and pay also. Impossible. How can, unless you admit the civil contract? Let them go to the, you have not filed affidavit also. You say that it is very difficult to file your affidavit.
My lord, in fact, that is reflected in an order. My lord, order dated 19/4/2024.
Let us dismiss it. Taking into account my Kumbhakarna judgment. Huh? Kumbhakarna used to sleep for 6 months. But Ripvin Venkel, do you know the story of him? Ripvin Venkel. Any of you? During the prior to the American Revolution, this person went to the forest. he had a wife and everything. He went to the forest. Then he went to sleep. He woke up one morning and he said, "Oh, I've gone old. Let me go back." He goes back, his wife has died, everything. The American Revolution was also over. So it is more than Kumbhakarna.
Lordship. After
This
90.
is one of the folk tales of from Ireland it went to America, and this is now their folk tales. So this is what Ribwing Wrangle. So my judgment may apply that and dismiss his petition, yeah? Chalo. This is an application filed by the petitioner seeking a writ in the nature of mandamus, thereby directing the respondent authorities to make payment of an amount of rupees 3,77,795 which the petitioner claims that he is entitled to in terms with the work order dated 17/7/2004. Full stop. This court have duly perused the materials on record. And from the materials on record, it reveals that there is a certificate issued by the executive engineer PWD on 28/1/2015 that the petitioner had completed 61.74% of the construction work. It further appears from some of the documents filed along with the writ petition that there was a revalidation of the administrative approval. But those are for the year 2015. Almost. And after 8 years therefrom, the petitioner has approached this court by filing a writ petition claiming the said amount. It is seen that this court, by an order dated 11/8/2023, issued notice keeping the issue of limitation open, which should be considered on the returnable date. Mr. P.T. Nair, the learned counsel, appearing on behalf of the respondent number 10, 9 and 10, 9 and 10,
Only 10, my lord. not
on
the
10,
subjects.
submitted that the respondent number 10 came into existence in the year 2017. And as such, they don't have any materials. Full stop. Even otherwise also, the respondent number 10 who had taken over the Cotton College under it upon its establishment do not have any records. And as such submitted that it would be difficult on the part. It is, and as such, they are not in a position to carry out any verification. The learned counsel further submitted that the delay in filing the instant writ petition. Is so colossal that if any direction is being passed for carrying out a verification and pay, the respondent authorities are not in a position to carry out any verification. Mr. B. Gogoi, the learned additional Advocate General, who also is the standing counsel of the PWD department, submitted. PWD as well as the finance department of the government of Assam had submitted that it is very difficult on the part of the respondent authorities to carry out a verification taking into account that the work order is of the year 2004. What is your instruction?
Yes, it is apparent from the annexes also. So you will see the para 8.
Do you admit to this?
No, this is the instruction that I have received, communicated to us. It says, madam, the pending bill is only this. Please 7777.
So pending amount is rupees so and so of the second, of the third,
Yes.
total is so and so. Do you admit?
It's there in the record as well.
So we therefore, submits it. It's a delayed so and so. Mr. B. Gogoi, the learned additional Advocate General who appears on behalf of the Finance Department as well as the PWD department, submits that the Executive Officer PWD, Dispur and Guwahati Territorial Building Division had provided an instruction dated 18/8/2024. He submits that this instruction can be taken as the instruction issued on behalf of the PWD department. The said instruction is kept on record and marked with the letter X. From a perusal of the instruction, it is apparent that the respondent authorities have duly admitted that the petitioner herein is entitled to an amount of rupees 377,795, which is the cumulative amount of the total amount of rupees 2,21,290 and 1,56,505, which is pending against the second and the third RA bill. Taking into account, it is also seen. So taking into account that the respondents have duly admitted to the said amount and the said work was to be, and the said work order was issued by the PWD department of the government of Assam, dated 2004. This court, therefore, is of the opinion that appropriate directions are necessary to be passed in the instant proceedings. So accordingly, the instant writ petition therefore stands disposed of, thereby directing the PWD department and more particularly
No, it's the higher education department, man. PWD has executed the work, my lord. It's for the higher education department.
you have issued. I am not concerned.
No, it's a lordship will say pays 100, man.
No, may pay 100. This
No,
is
in fact, for health department.
this is
also
your
it a-
notice. No, you have issued a formal work order.
My lord, we have issued.
Okay, we should direct the PWD department, more particularly the PWD department. No, this was- no, appropriate directions are required to be passed. It is also submitted that by Mr. B. Gogoi, the learned additional advocate general, that the said amount is to be paid
By respondent eight.
from the Higher Education
Yes.
Department of the Government of Assam. That is the respondent number 2 and respondent number 8. Taking into account that PWD department have taken up the construction for and on behalf of the Higher Education Department of the Government of Assam. Accordingly, this court therefore disposes of the instant writ petition with the following observations and directions. First, the respondent number 2, 4, and 8 are directed to take effective steps for release of the amount of rupees 3,77,795 to the petitioner. As the said amount is duly admitted. Huh?
At present, the university is there, so Lordship may implement yes, direct response number 10 also, Lordship.
No,
It's because formal proposal was sent from them, Lordship.
no, UP. I'm not.
We cannot directly, Lordship. We cannot directly, Lordship. Proposal was sent, proposal should be come from the Lordship college or now at present university, Lordship.
How will they give a proposal? They don't have any documents.
Lordship, we have also no document, Lordship. So Lordship may direct the.
No,
response also.
no.
No, otherwise, Lordship, it will be difficult. He will get Lordship money, but Lordship may direct the response 10 also, Lordship.
No. Lucky like line to likely.
প্ৰিন্সিপাল প্ৰপ'জেল পঠাব লাগিব না প্ৰিন্সিপালৰ ৰেজিষ্টাৰ আছে না এতিয়া এইটো আপুনি ক'লে নহ'ব না এইটো কথা এইটো হ'ব লাগিব নহ'লে দিগদাৰ হ'ব পিছত
This court further directs that in the said process, if necessary, the respondent number 10 should also be roped in by the said authorities. And the respondent number 10 shall also do the needful so that the petitioner is being disbursed the amount of rupees 3,77,000 so and so.
That will do, Lord. Otherwise, pays 100,
Next.
very specific, Lord.
The said exercise be completed within a period of 6 months from the date of the present order. From the date of the present order. Full stop. The registry is directed to provide copies of this order to Mr. K. Gogoi, Mr. B. Gogoi, and Mr. P. D. Nair, the learned counsels appearing on behalf of the respondents, so that necessary compliance can be made. First, this court further directs the respondent number 4 to file a compliance report, compliance affidavit before this court on or before 15th of June 2026 as regards the aforesaid directions.
ওলাইছে, Lord.
Oh, your matter, this matter. What is that?
Order was passed yesterday on TV. An order was passed previously by.
Yes, what order is passed? Who passed?
29/4/25.
I passed. That I know. Then,
Partial to the, my lord, they have a direct file an affidavit.
no, they have filed, everything has been done. There was a rejoinder affidavit filed also.
Here filing. Thereafter, my lord, if your lordship perusses 29/4 order, my lord.
Oh, why the matter has not come up? Oh, last time I said it after 2 weeks. Taking, you see what happens? When you don't appear, do you see the result? Hmm. So they will, how will they know when to file the affidavit? Isn't it, Mr. Bottakar?
Our affidavit might not, as per last order file, might not that.
You filed.
Yes.
After 29. After 29/4, I don't, we have not been served. Previously, affidavit.
Have you filed any affidavit after 29/4? No.
29/4, no. That affidavit.
The petitioner has filed a rejoinder to the affidavit filed by the so-and-so wherein it denied the contents of the report dated so-and-so and the so-and-so. Mr. M. Kolte appears on me, taking into account the sources directly to bring on record by filing an affidavit as required in terms with demand and also dealing with the allegations. Now, if you are not dealing with these allegations, because you see, they have made serious allegations. And on that rate, you produce the report wherein you say that these are the things, that these particular, all these things are not running. That was the report submitted. I said put it by way of an affidavit. If I remember early, this was the thing. But then you did not. Then the petitioner seemed to be not interested. Now they are again waking up after 8 months. So,
We'll file it, my lord.
another 6 months. How much time will you take? 8 months you have already taken to file their reply.
2 weeks maybe.
2 weeks, not possible. Be reasonable. Ask for 2 months. When you are not filing after till 8 months, so 2 months is good. It is seen that no affidavit has been filed by the respondent. Number 6. Isn't it respondent number 6? Divisional Forest Officer? I forgot. You were respondent number 6.
Above,
Divisional Forest Officer.
4, my lord.
Respondent number?
4.
It is seen that the respondent number 4 have not filed the affidavit in any affidavit pursuant to the order passed by this court on 29/4/2025. Though such liberty was granted to file on or before 13/5/2025. Mr. Ibor Thakur, the learned counsel appearing on behalf of the Forest Department, submits a final opportunity be granted in that regard. June? June?
Yes.
Okay. List this matter again on 18th of May 2026. In the meantime, the affidavit be filed on or before 13th May.
My lord, one clarification, can it be filed by 6, my lord?
My lord, actually,
Because
it
4 is the territorial
IIT,
DFO.
my-
4 is the territorial DFO, 6 is the field director, my lord. So field director will be the more appropriate authority.
No, who has given that report?
Report is by 4. Then
Because the field director will say, my senior has given the report, why should I?
4 will.
Don't you think that? See, I can, what? No, that makes no sense because you didn't appear. And whenever the matter is there, Mr. Kenchori wants to do whenever it is free. So I think this matter should be fixed on a particular date on which there is no other matters of this court. Because this matter cannot go anywhere else. Half of the judges, they don't take up this matter. And it is therefore tagged with me. When it is tagged, I gave some urgency to do it and therefore fixed it. But what to do? Can't help it. Isn't it, Mr. Botak? They are not serious. Are they serious, the petitioner counsels?
My lord, I won't be. the
You like
right
their
person to-
their lack of seriousness is beneficial to you, isn't it? Okay. File it by March.
March will file.
March 16 Koi report filed by 9th. What is the matter about?
Regarding non-payment. And my lord, the work has been withdrawn from the petitioner in 2023, August.
You have not terminated.
It was withdrawn, my lord.
What is this withdrawal?
It is page 145. My lord, it was withdrawn earlier. He gave an undertaking. He approached his honorable court and during the pendency of the writ petition, he made an undertaking that he will complete it. That undertaking is at page 141. This was given in, my lord. One page 132, if you'll also see, it starts from 131. In fact, my lord, the security deposit has also been, my lord, withdrawn by him.
Where?
The page 133, third para. Besides, the petitioner himself violated the contract agreement by withdrawing the performance security of rupees 20 from Bandit, valid till 31/1/2016.
What case does this petitioner have? Why is he taking time after time? Huh?
In fact, once it was withdrawn, page 132, if you'll also see the para 3, my lord, the entire facts are there, the short para. Work was handed over on 24/2015. He did not start the work. It was withdrawn on 18/8/2015. He approached the honorable court. Then on 5/3, he approached the authorities that he want to pursue the work. Then on 31/5/2016, he was again allowed to continue with the work. Then from, my lord, November 2022, he has,
So you carried out a joint measurement.
that perhaps, my lord, he has not cooperated.
Now, has the other work been completed?
My lord, that instructions I don't have. But even then, my lord, of 2015, we are in 2025. Otherwise also he cannot. Only prayer is, my lord, to allow him to, my lord, carry out the balance work.
So
Not about the,
only prayer, if that is so,
my lord.
you have to come up with the instruction that that work is no longer there.
My lord,
If the work is no longer there,
my lord,
the question does not arise,
my lord, my lord,
isn't it?
my lord.
So that is the instruction which is required.
Even in the meantime,
What
my
does
lord,
he submit? Oh, he must have submitted some reply. Wait.
yes, ma'am.
What does he say? How are these things being taken here?
In a, my lord, petition, otherwise, my lord, it's difficult. He can, my lord.
My goodness. That day also, this very contractor,
Yes,
that day, you were there, na?
yes, ma'am.
He insisted this court to be a civil court. You get that instruction
But
only.
that-
Has the work been completed or not? We then close it. Nothing can
Then
be.
within this week, my lord, I will have a short instruction.
Get that instruction as to whether the work has been completed or not, or has it been given to somebody?
Yes,
Because if it has been given, then we cannot touch it. Let it go. He will be entitled to any compensation.
compensation.
That's all, nothing more than that.
Lord, sir.
To stop. The petitioner herein has approached this court. None has appeared on behalf of the petitioner on call. The petitioner herein have challenged a communication dated 2/8/2023, whereby the work in question have been withdrawn from the petitioner to be withdrawn from the petitioner. And the petitioner further seeks certain directions to complete the balance work, to be permitted to complete the balance work after removing of the disputes of the project. Full stop. This court inquired with Mr. B. Gogoi, the learned counsel appearing on behalf of the PWD department, as to whether the remaining work has been granted, have been allotted to some other agency. And further, whether the work still remains to be completed. He submits that he will obtain the instructions, obtains the instruction within this week. Lists this matter on 19th December 2025 for appropriate instructions. Well,
Before Lordship, intending tender, challenge the settlement order paid annex 16, annex 1. Tender was issued at the time of COVID-19 and below government revenue was 3,35,400, but we has paid only 3 lakh. Is being
Not
telling you
clear.
that there is no any wide publication at that time.
We'll file our
We also
affidavit.
doubt
You,
because
you submitted the bid.
no, my
No,
Then
My lord, because of that, at that time of COVID-19, no public is there, madam. Not, NIT was not widely publicized.
Then-
Only one person participated and revenue was, fix was 3,35,000.
is this a public interest litigation?
No, my lord, but
If you have not submitted,
my-
where is your grievance?
my grievance is that, my lord, at that time of the COVID-19, there is no wide publication whereby we are not participating.
So
I
what?
don't know. But only one person is participating, but he has below revenue, madam. And now he has not paid any government below as per RTI also, madam.
If they are not paying it, then they will do the needful.
But I have filed a representation, madam, that was also not considered by the authority.
No, it's okay, but why will they will take, if they are not paying, they will duly take action.
By that is a government, madam, he has, madam,
For that, you need to file a PIL.
for, madam, I am challenging the, he's not,
Lordship will file our affidavit clearing our stand, Lordship. I have to obtain instruction.
You have
Lordship.
not filed your affidavit.
No, Lordship.
So old matter,
Yes, Lordship.
2 years.
Yes.
Then-
If it is yet to file, will within 2 weeks, Lordship will file our affidavit.
Reopening. File your affidavit.
Yes, Lordship.
More particularly as to whether there is a default committed by the private respondent,
Yes.
and if so, what steps you are taking. It is seen that though notice was issued as far back as on 30/8/2023, and even after a lapse of more than 2 years, the respondent AFDC have not filed any affidavit in opposition. List this matter on 9/1/2026. A final opportunity is granted to the respondents, including the private respondent, to bring on record their stand by filing affidavit by 7/1/2026.
of 7,
I'm having it on 9.
minus.
They have to file the affidavit. You want to be present here when they file the affidavit?
Yes, sir. All right.
Mr. Doctor, first tell me, in those batch of matters, you had only 2 petitions?
Yes, yes. I have 2 petitions, I am representing the claimants. I, for the claimants.
I know that. You are not an insurance counsel.
I have submitted.
I've seen it. So I was just, because certain conclusive directions are required to be passed. So therefore I was looking into it. Yesterday I dictated the judgment and it will be given this year only. By the end of this week, I'll and try to give it. It has become long, but then, anyways, tell me.
Lordship, in this repetition, we have challenged the Pakizai notice issued by the certificate officer, challenging that Pakizai notice along with some other notices issued from EFO demanding some amount. So thereafter, this court, on the very first day, issue notice. And in the next day, recovery in terms of the notice with the so and so. It is one of the notice which we have challenged. As the proceeding was not stayed, therefore we have participated in that particular proceeding. And we have submitted our petition denying liability. Thereafter, that matter was not, yet the certificate officer had not determined that. Certificate officer.
Why are you challenging the Bakizai proceeding? Is it without jurisdiction?
There was no agreement, there was no signed agreement. And then,
No, no, no. When does the Bakizai proceedings started? It's more like an execution proceedings. There must have been some order or some request made by the forest department or mines department, whoever it is. They must have requested them that this is the government revenue, kindly realize it. The Bakizai authority has due jurisdiction to act on that, and you have a scope for submitting a reply. But unless you challenge the demand so made by them, can you challenge the Bakizai proceeding? My question is that.
in that petition denying liability, which I have submitted. I have submitted,
No. Here. Have you challenged that thing? What is your challenge here? What is 18/6/2022? Where is that?
2022, page.
This is direction to make payment. So you are challenging this. Yes, you are challenging this
Yes,
of 35 lakhs.
yes.
Then 27/6. You are directing for making payment.
Yes.
This is another notice. Then
Then, this.
Bakizai proceeding. So you are challenging this 18/6 and 27/6.
27.
So this is the primary. You have challenged it. What is your ground of challenge?
Due to non-obtainment of one of the environmental clearance certificate, that which was submitted during the immediately after the beginning of the COVID-19. I could not, my renewal for the third environment clearance was lapsed on.
You wanted to surrender.
Yes, I have already surrendered.
When did you surrender?
I have surrendered on the
15/12/2020,
yes,
he made an
15
application for surrender.
Page 18.
21/1/2021, page 83. You submitted your request on 15/12/2020.
Yes.
And what did it say? May accept the contractor's request to surrender of a contract or part thereof in cases where it is established to operate. Hence, you are asked to fulfill all provisions required in so and so. You are a defaulter.
He's a defaulter.
Thereafter,
Surrender of so and so and so and so.
we have
You are a defaulter even for the first year.
Malad, but that was not Malad earlier, Malad notified Malad. Now,
So-
whatever I have paid, Malad, I have, whatever required, I have paid.
No, do you deny to this?
Yes, ma'am.
These are all prior to COVID.
But earlier, my lord, I was paying regularly. Till the third, my lord, the third year, my lord, I was.
These are all interest on interest on MMDR. How do you challenge this? And why have you filed affidavit?
Oh,
Lord,
I'm not-
we
You
haven't.
don't
filed
want
the-
to file affidavit.
The issue that we were awaiting updated instruction, we have received the updated instruction. Now the issue is that he's saying that he never got the environmental clearance. The petitioner never approached the sea authority for environmental clearance, Your Lordship. He never approached. the
How
authority.
will you consider such submission without your pleadings?
We'll, just a one line affidavit, will file, Your Lordship.
Why you have not filed?
Because this is received the
Huh?
updated instruction, Your Lordship. I'll
The
file with
stay was granted as
Stay.
far back as 2 years back.
2 years back, Your Lordship.
So you don't want. So we have it in after 2-3 years.
Let it come, Mother, I'll file.
2-3 years.
No.
After 3 years, because we say, make it very clear that this order is being passed out here. There is a stay, you are not bothered.
We'll file, Your Lordship.
And as such, we have it on, wait, we have to see our mobile then to get the date in 2028. 2028 we'll have it. We have taken a decision to give dates nowadays. How about 12th of June, 2028? How about it?
Let it come immediately after vacation. I'll file.
You
Immediately
file
after.
your reply by this week.
Very well, Lordship.
This week. If you don't file, we are not going to have, we'll make it, we'll have it in the year 2028. Full stop. The petitioner herein have assailed the various communications by which certain demands have been made by the Divisional Forest Officer Golaghat, directing the petitioner to make payment. It is further seen that as the petitioner did not make any payment, thereupon also, Bakizai proceedings was initiated by the Bakizai officer which is also the subject matter of present challenge. The record reveals that on 22/9/2023, that is more than 2 years earlier, that is more than 2 years ago, this court issued notice and further passed an interim direction not to proceed with, not to make any recovery in terms with the notice dated 4/8/2023. The record reveals that whenever the matter has been listed, the Forest Department have sought for time. And the interim order have been extended from time to time. In spite of opportunities being granted, the Forest Department took time on 10/11/2023, 28/11/2023, 1/12/2023, 8/1/2024, 22/1/2024, 15/2/2024, and 27/10/2025. But till date, the respondent of the Forest Department have failed to file any affidavit. It therefore appears that the respondent Forest Department has no urgency in the early disposal of the instant writ petition. Rather, for the purpose of on account of non-filing of the affidavit, the instant proceedings have not proceeded to the stage of disposal. Mr. R. Gokoi, the learned counsel appearing on behalf of the petitioner, a respondent Forest Department, submits that the affidavit will be filed on or before 19/12/2025. Considering the above, list this matter on 7/1/2026. Interim order passed earlier shall continue till the next date. It is observed that if no affidavit is filed by the Forest Department within the time permitted herein above, comma, it shall be construed that the Forest Department have duly accepted the stand of the petitioner in the instant writ proceedings, and by applying the principles of the doctrine of non-traverse, this court shall proceed to dispose of the writ petition.
Obliged, Your Lordship.
What is this?
That so for installation of mobile tower, madam, we have earlier approved the Sonarpur code method. The Sonarpur code, the page my lord 64, directed the deputy commissioner to come in a meeting and so for our grievance is concerned.
Why are you challenging the area of the mobile tower?
Installation of that mobile tower is concerned within the residential area.
Within?
Residential area. Or just adjacent to the residential.
In your land.
Not my, but neighbor's land.
So,
So for the other installation of DV tape and other, so for the installation of other machinery equipment there on my other sleep or other minor daily activities have been disturbed. And
what
in
is
that,
disturbed?
I do not sleep my every night because due to the sound from coming out from the mobile tower as well. as
Radiations. And
sound of the DG set,
of the
the amount of electricity for supplying.
you have the problem with the DG set, not the mobile tower. Mobile tower doesn't have any sound.
Sound,
Then
in that tower, they have also installed one DG set, right?
DG set.
Yes, DG set means it is for providing current, electricity.
Then
But also for the other, all the neighbors, of that locality, where though persons are facing some problems, noise from that particular area, but for which they cannot speak like. Even when the patient inform, 2% have get mild infection.
2%
They are going under medical treatment for cancer.
because of the radiation.
They might take, yes, sir.
Okay, so you must have produced some scientific documents in that regard.
Earlier, this application, the business approved this honorable code. Page 64 is the order of this honorable code. And whereby they specifically directed to the deputy commissioner, page 72, paragraph number 7.
Huh?
Page 72, paragraph number 7.
72.
72.
Yes, what is the direction?
Direction was given, paragraph 7, taking note of the provisions contained the so. This code is of the considered view that the requisition can be disposed at this stage with the direction to the respondent of code to place the representation submitted by the case person in respect of the proposed mobile tower before the DTC suitable for consideration, and the DTC suitable shall in turn take the same on board consideration After due consideration, the DTCs have disposed of the same by passing a speaking order. It is accordingly directed, it is necessary to mention that at the time of consideration of the said representation, all the stakeholders of the authorized representative shall be put on notice and an opportunity of personal hearing be accorded to such interested stakeholders. In relation.
So you want a similar direction?
That does not comply. That does not comply.
You had approached earlier,
I have approached it. Some of the petitioners approached earlier. With a similar
where you are
case
party
by
or
solution.
party to the
Yes, yes.
petition?
Yes, yes.
Who are the petitioners who are party to the petition? Then the DTC director, DTC Sipsagar, who is the party?
Deputy Commissioner number 4.
No, the direction is DTC Sipsagar.
Chief Service.
Where is he?
DTC is headed by the Deputy Commissioner.
How do you know?
That's
The
what-
direction is to some DTC,
An affidavit has been filed to that effect.
chairman of the district telecom committee.
Right.
Who is the chairman? You are? You have been submitted a representation.
Yes, my lord, that has been considered, my lord. That has been considered. We have filed the affidavit, my lord.
You have considered?
Yes, my lord.
Where is it?
Yes, my lord. First, lordship may peruse the paragraph 5 of our affidavit, my lord.
Where is the consideration speaking order? Where is that speaking order?
Speaking order, my lord.
Huh?
Page 77, my lord. No.
Where is the speaking order?
Page 112 speaks, my lord. No speaking order was passed. This is the aggregate part.
What?
Page 112, my lord. Affidavit filed by the justice number 4. Part of paragraph number 9, right?
Wait, Mr. Setia, kindly read paragraph 7, page 72.
Yes, my lord.
What is the direction? What is the direction at page 72?
72, my lord.
Para 7.
Yes, my lord. Thanks, my lord.
Where is the speaking order?
That order has not been, my lord, annexed to our affidavit, my lord.
Huh?
That order has not been annexed to our affidavit, my lord.
You filed the affidavit when?
That affidavit, this is filed on, my lord. 4/3/2024, my lord.
So you don't think that this is the requirement?
Yes, my lord.
It appears that the DTC, Sipsagar, or for that matter, the chairman of the district telecom committee is violating the court's order. So we initiate suo motu proceedings against him. Contempt.
Lord,
Don't you
that-
think, Mr. Sharma?
Yes, my lord.
It's a case of suo motu contempt.
No, my lord, he have considered, my lord. Committee had considered, my lord. But my lord, report has not been, my lord. Order has not been annexed.
Does
to
it
that
take
affidavit.
for you another 3 years for passing that order?
Yes, my lord, I will produce, my lord, next week, my lord.
This week, the speaking order, else we construe that there is a violation. 18th. Let us
Yes.
see the speaking order.
Yes, my lord.
This is the second time some of the petitioners have approached this court. On account of non-consideration of the representation so submitted by them to the DTC, to the District Telecom Committee, to the chairman of the District Telecom Committee, Sipsagar. Though there was a specific direction passed by this court on 13/6/2022 in WPC number 3235/2022, whereby this court specifically directed the DTC Sipsagar to dispose of the representation to be submitted by the petitioners in that petition
My lord,
within, by giving.
may Lordship may pointed out to the page 77, my lord. The minutes of meeting is there, my lord. Yes, my lord. Last paragraph, my lord. Seventeen 2022 or minutes of meeting, my lord.
Hmm? Who is paying for the Reliance? Geo?
Name has not been shown, my lord.
Anybody appearing? Mr. Sharma, you should make the Geo as a party. Why are you not making the Geo as a party?
And again,
If you want to get things done, you have to catch hold of the proper person. What is this manager going to do? He has no business out there.
14 is there. 14 is there.
Your service center.
Yes, yes.
Why are you not making that particular? You want this,
Yeah.
then only it will happen.
Yeah.
They're not bothered. This person will come, this person will go.
Yeah.
But you are having a bigger issue out there, and more particularly in view of that minutes. And why you are not making the Union of India party? Union of India is made a party. Who is appearing? You are not only you. Who is appearing for response number 4? Who appears for the director of DOT?
Yes.
Huh?
Yes.
Who appears for this? Director of telecommunication DOT? Who appears for that? You have, Mr. Why you are not making him a party? Hmm?
I have to make party, madam. You,
And why you are making the try a party? Unnecessarily. Try is a body who can look into this, your complaint. Why you are making him a party? He should not be made a party. Tomorrow are you going to make the High Court a party? The High Court has decided it.
as soon as he has wrongly been. Yes.
You have to make DOT a party.
Yes, I have to make party. I will
You have to
file-
make Reliance company a party.
Yes,
You are having,
yes. I will file it.
what does the Sibsagar Development Authority has to do?
They have Park have submitted some,
No, your issue is what?
my issue.
That
currently
look here, there are certain radiation levels. There is a noise pollution also. As regards the noise pollution as well as the air pollution, the Pollution Control Board is to look into it, which they have not looked. One. As regards the radiation level, the DOT is to look into it. And more so when the Reliance manager who was present there have categorically stated that they are closing the towers in view of the radiation. So therefore, this is there. The second is you have to make these, the central government out there, ask them what directions you are passing. This is a more bigger issue
Yes, yes.
than what you are asking for. It is not that you are not able to sleep.
Yes,
It has a much bigger connotation how you are doing to do it.
I have to file application, appropriate application for bringing all the parties.
And there has to be specific averments against them.
Yes.
The petition should be made in that manner. It is not a question because he cannot look into that. This is too small a authority to look into this bigger issue.
Yes,
You have to have the Reliance Jio, the company, a party. You have to have the union, a party. You don't make TRI a party
yes, sir.
because you have not approached TRI. Have you approached TRI? No.
Prior to installation of that tower, model, this petition was initially filed subsequently when the preparation was going.
No, no. Have you approached the TRI?
During the pendency of this, we have no.
No, no. I'm asking you, have you ever approached the TRI? So why you are making unnecessary and it is a quasi judicial body. They pass various directions. Have a look at that particular guidelines. Not the guidelines, they have this particular act, the TRI Act.
Yes, ma'am.
Have a look at it. What is their functions? You need to amend your petition accordingly.
Yes. Yes.
Not only making all these things, because you are asking a very small issue as to what they have done. They have not passed a speaking order. It's too small an issue compared to what you are actually asking. It's too big an issue. So you need those people out there. The Ministry of Telecommunication, the sound pollution. Where is the, if there is a sound pollution, have you informed the Pollution Control Board out here? That this is the sound pollution, kindly look into it. Have you informed him?
Not informed. My lord.
If you are not informed, how do I pass a direction? I'm telling you, today,
Yes,
I was not supposed to sit today. Therefore, I am taking a irregular type of bench. So I have very less matters. I have time today. But you have to have those things. You have a good case. More particularly taking into account that minutes, page 77. You have a good case. But this is only very small case. You are making out a very small case. The bigger issue is as regards the radiation. What scientific data they have that there is no radiation, it is not happening. You are saying that 2% is suffering from cancer and all. These are all scientific evidence. Find out those. You have to bring those assets. So therefore, what are they doing?
yes.
What are the guidelines of the central government as to whether they are meting it out? Therefore, they have not filed any affidavit also. Central government, no affidavit.
No,
Therefore, they are not filing it. You are restricting to the district.
yes. I have to file appropriate.
You have to be in the ocean, not in the well. Don't you think so?
Yes, yes, yes. Issue is such.
So you either do whatever you feel like. I adjourn the matter today. Think about it. I think you should withdraw and file a composite writ petition properly, making whom a party. You have to remove TRI. You have to make pollution. Pollution, you have to inform them that look here, this is the pollution we are facing, the sound pollution, in view of the DG sets. And we'll look into this. You have to inform the Ministry of Air, as well as they have particular officials also who looks into this radiation. Find out those. Then you have to move that. At the end, you are not going to get only a direction to the here to look into a representation is too small a thing.
Yes. I may be allowed to file appropriate application for amendment of my amendment petition.
You want to amend, you have to, not only you have to amend your writ petition, you have to delete many respondents, you have to add many
Yes.
respondents.
Yes, yes.
Think
See,
about it.
application.
I adjourn it for a week after vacation. Give a thought about this thing, what I've said. How you can improve. You have a good case, but you can have to develop your case.
Yes.
It's too small a case you are there. Okay, Mr. M.K. Sharma, the learned counsel appearing on behalf of the petitioner seeks for certain accommodation, taking into account that the accommodation as he requires certain instructions from his clients. List the matter again on 19th,
But 19 this month.
not this,
Fine.
19/1/2026.
All right.
In the meantime, you, Mr. Sharma, you can withdraw. In the meantime, withdraw and file a fresh one. Better one.
Yes.
Yes, oil, M. Bormon. None has appeared on behalf of the petitioner on call. Labor Department. Mr. M. Sethi appears on behalf of the respondents, numbers 2 to 6 and 1 to 6. It is also seen that an affidavit in opposition has been filed on 11/12/2023. But the respondents have not petitioner have not chosen to file any reply. Considering the above, for the ends of justice, the matter stands adjourned to be listed again on 9/2/2026. Considering the above, this court, for the ends of justice, adjourns the writ petition to be listed again on 9/2/2026. It is observed that if the petitioner is not represented on the next date, this court shall presume that the petitioner have lost interest in the instant petition. Yes, what is this? Non-payment?
Non-payment, no. My instruction is awaited money.
With direct as per Tamsir,
Lots of.
disposed. No, this one. Rule issued, it will amount to order us. It order to cycle DD to be listed along with that petition. Same e-subsidy, na? Yes, have you filed your affidavit?
No, Lordship.
Why?
Up-to-date instruction not received, Lordship, just for, he will not just receive, Lordship, that he is not entitled for 16 weeks, only he is entitled for, sorry, Lordship, he is entitled for 17 weeks, he is entitled, Lordship. We have calculated that and it has 17 week,
He's entitled to how much?
17 weeks is entitled to 1,53,000. because board has taken a decision for remission of at the rate of 25%, Lordship.
In 1 year, it is 20 lakhs.
Lordship.
And he's entitled to how many weeks? 17 weeks.
17 weeks. 17 weeks.
17 weeks, how much then it would be?
17 weeks at the rate of 25%. It's come to, as per our calculation, it comes to 1,53,908. That I will bring in on affidavit, Lordship. This was not clear how the minutes was also not there.
The petitioner asks for 1,73,000.
Lordship, he is, yes, Lordship. And there was a balance of 10,38,889.
So there is no stay granted by this court.
No.
Okay, we grant a stay.
Lordship,
Don't take. No, you have not filed your affidavit.
Lordship, that's market has not yet. The stay, Lordship, there was, we are, the board, there was a balance of 10,38,800.
Has he paid the amount?
Not yet.
Okay, with state. This court had issued notice as far back as on 22/11/2023, whereby this court inquired with the respondent authorities to provide details as to whether the amount of rupees 1,73,146 would commensurate for a period of 18 weeks, taking into account that the bid amount was rupees 20 lakhs 786 for the period from 1st of April 2021 to 31/3/2022. This court further directed the respondents to bring on record their stand, to provide instruction as well as to file, to provide as well as bring on record their stand. However, no stand has been placed. Consequently, it is therefore the opinion of this court that the impugn order by which the petitioner has been directed to deposit an amount of rupees 10,19,627 being prima facie without any due reasons is required to be stayed pending disposal of the writ petition. Accordingly, is required to be stayed. Accordingly, this court therefore stays the demand upon the petitioner of the amount of rupees 10,19,627 by the communication dated 13/3/2023 till the next date. List the matter on 18th of February 2026. It is observed that if the Tinsukia Municipal Board does not file any affidavit on or before the next date, it shall be assumed that they have duly agreed to the terms and to the contents of the to the contentions of the petition, and on the basis of, by applying the principles of the doctrine of non-traverse, this court shall take steps for disposal of the writ petition. Yes.
Lordship, my stand is at paragraph 4 of the affidavit, Lordship, if Lordship comes to page 35.
Forty-five.
35, Lordship. 35, paragraph 4.
Wait. Filed by whom?
Filed by the GMC authority, Lordship.
Respond
by
number
one
4?
Dipu Kumar Deka, yes, respond number 4,
Para 4.
para 4, Lordship. No, Lordship, why I'm saying so, Lordship, it is a bit.
In that paragraph, Lordship, last paragraph, this one we put, 440 instruction. They had disputed them, third party monitoring committee, board of the third party monitoring committee, as well as the photographer. Therefore, the consequential completion police dialogue.
Did the third party sign it? Now, my question is, did the third party sign it? Isn't it required for the third party to sign it? Completion certificate?
Completion certificate issued by the PMC. The consequential completion certificate.
Huh?
Completion. Page number 25, 24, 24 onwards.
Page 28 of the writ petition? What do you say, Mr. Naik, as regards page
Lordship, if
28?
Lordship comes to page 36 of my affidavit, one word is there. Page 36, this is part of para 4, Lordship. If Lordship takes last two line of first paragraph, Lordship, it was observed by the superior authority that no documentary evidences of supervision carried out from the third party monitoring agency were furnished. Now, if Lordship comes to page 18 of the writ petition, Lordship, Lordship will first see the period.
Page 18.
Page 18. Please. Two works were there, Lordship, one 5E, one 5G. In the middle portion, Lordship, for the year 2018 to 20. That is from March 2018 to March 2020. Now, if Lordship comes to page 20, this is the first certificate of supervisor. This is the third party supervisor, Lordship. Lordship may kindly see the period March 2018 to May 2018.
That is the only, no, the other one?
Other one in Lordship comes to the second one, Lordship.
That is till
Page
31.
23, this is in respect of G, same period, Lordship, 2018 to May 2018. But then
What about
then
page 28?
page, before that, Lordship, page 26. Page 26,
Where's the word number?
Lordship.
You see, page 18, this work order is for word number what?
Lordship, two works are there. One is
Package
5E.
number
Package
C and
number.
D, so and so in GMC area. What is that package?
Package number,
Both
last word, Lordship, will say 5E,
5E and the other is 5G.
5G.
Ah,
Lordship, these supervision certificates, he annexed some supervision certificates. Now, Lordship has seen the first one. This is from March to May 2018.
this is pertaining to 5E.
Both the certificates he has annexed.
C is 5E.
Yes, Lordship. One is 5E, one is 5G.
Bhaini road to, this is ward number 26.
Yes. In 23, Lordship, same, it is G, and period is March to May 2018.
The other is 28 and 29.
Yes, if Lordship comes to page 26, Lordship.
Word number 28 and 29. Okay, then
Page 26,
26.
yes. Now Lordship will see the period of work 1/12/2018 to 30/11/2019.
Hmm.
So the supervision report for the period from May to December 2018 is missing.
Hmm.
That is what has been mentioned in the affidavit, Lordship.
Hmm.
Same period, same Lordship, if Lordship comes to last one, Lordship, page 28. Lordship may kindly see the period 1/12/2018 to 30/11/2019. And the last one is at page 30.
Till 31/10.
31/10/2020. The period was up to March 2020.
So they have supervision from that to that, but they don't have for the period from June to December
From June to December is missing.
2018.
Then November to March is missing.
November of
Page 30, Lordship.
page 30.
Yes.
This is 1/12.
1/12/2019 to 31/10/2020.
And the earlier one is, no, 1/12 because you see the earlier one, annexure E page 26. Is 1/12/2018
Yes, that portion is there.
to 30/11/2019.
Yes.
So therefore they start with 1/12/2019.
So one portion is missing in the.
Only one portion is missing.
19. Now, Lordship, if the work or proceed to work is for the period from 18 to 20, it is for the period from March 2018 and in my understanding, March 2020. So this is a period, Lordship, which is beyond that period, Lordship, first. And even if it is to be read as it is up to the financial year 1920, then also it is beyond March 2020, Lordship.
You are not clear. For the year 2018-20.
Last one, Lordship, will see at page.
You must have to have this must have been done pursuant to some notice inviting tender.
For the subsequent period, Lordship.
No, for that no issue of notice to proceed with the work
Yes,
must be on the basis of some notice inviting tender.
yes,
So the notice inviting tender must have stipulated the period.
yes, that is what, if Lordship comes to the last line.
Anyways, now I was just waiting for Mr. S. Bottakul to dismiss his writ petition. Come. Yes, Mr. Bottakul, now you come. I was just giving him the chance to get the. No. I don't want to dismiss in his hands. I want to just waiting for you. Yes. Okay. Go to the civil court. This court cannot.
One more reason, Lordship. One contract is there. One contract was there, Lordship. Rights and liabilities are to be decided on the basis of the terms of the contract only. That is not before your Lordship.
No, Mr. Bottakul, all these things has to be done before the civil court.
Lordship may be only one aspect, your Lordship. There is a contract, your Lordship.
First of all, you have not enclosed, more particularly, the notice inviting tender. How will we know what is the period?
Lordship, that your Lordship, I can, your Lordship.
No, not the one. The second is, they say that because in the notice inviting tender, you will have the terms and conditions.
Lordship,
They say that photographs are required.
Lordship.
How will I know?
No, your Lordship will kindly see.
They say that photographs were not taken while
Lordship,
making the supervision by the third party.
Lordship, that is probably your Lordship will kindly see their affidavit, your Lordship.
Yes.
for a moment. They have not annexed the order, your Lordship, on the basis of which your Lordship, they have said that these photographs were not there, but they made a statement at para 4, your Lordship.
I've read it.
Lordship. Now your Lordship will kindly see there is a contract, your Lordship, a word of contract. 2/3 of the amount has already been paid to me, your Lordship. Only in respect of that contract, 1/3 is to be paid.
Now, your lordship,
Which part?
lordship,
Which portion is to be paid?
maintenance, your lordship.
Which portion? 1/3 means which portion? Because you don't have,
No,
for the
It's a
purpose
contract for 3
from
years.
June to December 2018, you don't have supervision.
no, your lordship will kindly see, first year they paid your lordship, second year they paid your lordship. Third year in respect of 1/2 your lordship, one part your lordship, they have not paid as your lordship. Now, your lordship, there is an order, your lordship, there is a completion certificate issued by the your lordship, the executive engineer, their engineer. Then, your lordship, there is a report by the your lordship, the third party,
Where's the
they have
report?
engaged for
Where's the
supervision.
report from June 2018 to
Lord,
December
This
2000?
is the period, your lordship, for which we are to work, your lordship.
Where is the report? Where is the report of the third party
Your
for that period?
Kindly see, I have annexed every report, your lordship.
No, you have no.
Everything, your lordship,
Okay, let us see.
lordship. I
Yeah.
show that, your lordship.
Certificate of
Whatever.
supervision from June 2018 to December 2018.
Third party maintenance, your lordship, page 30, your lordship, may kindly come.
Yes.
This is the, your lordship, one.
This
contract.
is the period from 1/12/2019 to
For that period,
31/10.
your lordship, amount has not been paid to us, your lordship.
How do I know? They must have assessed it. Okay, earlier they have already paid, but you don't have the certificate for that period.
Yes, your lordship, I have,
Where?
your lordship.
Show me the
Yes,
certificate.
yes, I will show that, your lordship,
Where?
everything, your lordship.
Yes.
Your lordship will kindly come to page 20.
Yes.
This is for the period March 2018 to May 2018.
Where is from June 2018 to December 2018?
Your
That is
lordship
what?
will kindly come to next, your lordship. This is also March to May. Then your lordship,
There.
then your
Where?
lordship.
Where is that
26.
period? From June to November.
Lordship. March to May, your lordship. And then your lordship will kindly come to page 24. This is the completion certificate. It reflects everything, your lordship.
No. Where is that period? Supervisory.
That will start from 2019, your lordship.
Why?
There are two parts.
Because that period is not there from till May 2018.
Your lordship will kindly come to page 26, your lordship.
That is what I am saying.
1/12/2018.
So therefore, where is that period?
No,
Till November 2018.
lordship, that period is not required, your lordship.
Why?
That period is not required, your lordship. First part, your lordship. It's second part, your lordship. Maintenance is for the whole year, your lordship.
So
Maintenance.
then if that be so, if it is not required, why do you have a similar certificate for that period in the year 2019 and 2020?
Because 2019 and 2020, it is for the maintenance, your lordship. It is only for the maintenance period, your lordship. There are three parts, your lordship. First two, your lordship, for first, second and third, your lordship, only for the maintenance.
The
That's why
first
your
part, the
lordship,
first part is for what?
lordship will kindly see.
This is cleaning, desilting, maintenance.
First, your lordship, cleaning.
So there is,
and
therefore,
desilting.
there is no maintenance required. Are you saying that there is
Yes,
no?
in the first year, your lordship, only cleaning and desilting. Then next 2 years, your lordship, maintaining, your lordship. That's
Okay, Mr. Botago, kindly come to Annexus C,
lordship,
page 20.
lordship.
Cleaning, desilting, maintenance.
That is the work, your lordship.
That, why you are saying that maintenance is not required?
In the first.
I think
your
no,
lordship will
we
kindly-
don't grant leave
kindly
also.
give
This
me
is-
one chance, your lordship.
No, we
Your
dismiss,
lordship,
we dismiss
kindly
it.
give me one day.
No, no.
I will annex everything.
No, you have very good.
No, your
No, the
why
division bench.
why I
Division
have no-
bench.
your lordship-
Remaining is for division bench
No,
to
if-
consider.
What I am submitting. your
No,
lordship.
I am not going to look
Just
into
for
it.
a second hearing, your lordship. Just for my satisfaction, your lordship.
You were given the satisfaction
Well,
earlier.
that is fine, your
The,
lordship.
earlier you had kind
Otherwise, I
judges.
don't take much time, your lordship. I will give a brief.
Unluckily, today I was not supposed to sit also and it came before me.
Lords, I was not, your lordship will kindly see, your lordship. A work was executed by a contractor. After your lordship 2 or 3 years, they will come and say that they have not executed. Why have you done, what action you have taken against these persons, your lordship, who has issued this certificate, your lordship, who has released the amount, your lordship? Now, it will
Okay,
be a
we
dangerous
record your
precedent, your
submissions, Mr. Nayak. Take action for not doing work for that period. And whatever payment you ask made, take up that payment also. Because if a particular period they don't do, it leads to more problems in year 2019 and 20. Don't you think so?
Now, your
If-
lordship
if-
will kindly see what has fallen from your lordship's mouth. That has not been in their pleaded case, at least. Your
Lordship,
I
completion,
have got chance
completion
to rebut it,
certificate,
your lordship, had this been come in the form of pleadings,
completion
your lordship.
certificate is one requirement. At the same time, supervision carried out by a third party is another requirement, Lordship. If Lordship comes to the completion certificate, that is a.
Tell
test
me
cer-
one thing,
test-
I have very difficulty. Office of the Principal Girls Polytechnic. Are they appointed as supervisors?
I don't know, Lordship, on what basis they
Because
came in.
on what basis they are
Yes.
carrying on the supervision for a year from the area from Ganeshguri flyover to this Bhagadattapur outfall drain, Dokhin Gao main drain. How
And
can
it-
they be unless you are appointing them specifically as supervisor?
And all these supervision report, Lordship will see the same wards, only those handwritten portion, Lordship, so far as the period is concerned.
No, but we understand, we want to know one thing. How can they be appointed as a supervisor unless by an authority, by an order, by a communication, this particular person has been appointed to look into this entire area? I would have understood.
Yes.
Normally, we see a lot of supervisions made in respect to the schools, where apart from the PWD or anybody else, or the education department, whoever it is, there is a supervision by the school authorities. Because they are in a position to carry out this supervision,
Lordship,
because it is within their campus.
Lordship.
But how a principal of the Girls Polytechnic can make a supervision from Ganeshguri flyover to Dokhin Gao main drain, such a huge area that is encompassing the entire ward number 26.
Not
Is it
in-
possible?
Not only in respect of this work, your lordship, they are made supervisor in respect of all other cleaning works, your lordship. Yes.
Lordship,
I have found
there was a contract, Lordship, and I think it has.
What is the role of a supervisor?
Lordship, after execution.
No, you are saying from where?
Lordship, no, your lordship, as I have been instructed.
No, instruction can't help it.
No, then your lordship.
No, why should we look into it? It is
No,
your
no, no,
case.
then your lordship, I will file.
You have not filed.
I will have to file an additional.
Long time we have given you file to file. How
No,
many
not
years?
For this, your lordship. Last
311.
order,
It is almost 1.5 months.
Your lordship may kindly see last order, your lordship.
Whatever last
says-
order. Last order is different.
produced, Your lordship. Your
You-
lordship, will give me one chance. Ultimately, your lordship, why I am. before
First
this
of all, you have to therefore say that the supervisor is not required. One, supervisory role has no business. Two, photographs of the supervising is not required. And what is the proximity to know what is the period is not mandated in the contract. There has to be a contract.
Lordship,
Where is that?
no, lordship, that I will bring. Your
You have
lordship,
filed
because
your
lordship,
reply,
these are-
everything, but you have not
This-
mentioned. Have you
this
filed
has
your
come from
reply?
Your lordship's mouth.
Yeah, this
today
type of
for the
case
first
is
time,
not
your
done.
lordship. Whatever your lordship has earlier occasion, your lordship has asked me to annex one copy of the document I have annexed, your lordship.
Which one?
That's by additional affidavit, your lordship.
What did you do?
That's your lordship, letter of acceptance, your lordship. Only that your lordship has directed me, your lordship, I have, your lordship. Now, your lordship may give me one chance, your lordship, I will bring all these, and thereafter, if your lordship is not
What is that
satisfied,
letter of
dismiss my
acceptance?
petition,
This
your
is to
lordship.
notify that your bid so and so for the execution of rupees so and so. Yeah. At this work was of very urgent nature and first phase is to be completed by May 2018. You are requested to proceed with the work in consultation with so and so. Yeah, letter of acceptance. Did I ask you to do that?
Yes, yes, your lordship.
I can't.
Yes, your lordship. your lordship order.
Taking into account the submissions made by Mr. P. Nag, Mr. Botha appearing on here submits that he would like to file an additional. I never said that.
No, your lordship has pointed out to me where is the document.
I keep on
Then
pointing
not
out, it
directed,
will
your
keep on
lordship has
changing.
observed, your lord.
Now I think I am pointing out to go to the civil court.
Lordship.
Huh?
Once, your lordship, if thereafter your lordship. is
Ask,
not satisfied, your
why,
lordship, I will.
why don't you want Mr. P. Nayak, the additional advocate general, to appear in the civil courts? Why should he always be here?
He is busy here, your lordship.
Huh?
that's why. He is too busy here, your lordship.
I appear. I appear in many cases.
Are you too busy to appear in the civil court?
No, I go there also.
Oh, you see, he also says.
Once, your lordship, I will, your lordship, bring everything, your lordship, which is.
Lahok heard Mr. S. Bhattakur, the learned counsel, appearing on behalf of the petitioner, and Mr. P. Nayak, the learned additional advocate general, who also represents the Guwahati Municipal Corporation. The petitioner herein has approached this court claiming an amount of rupees 24 lakhs 35,539. What is this? Two amounts.
The amount, two work orders.
Amount of rupees 20 lakhs 45,220 and 24 lakhs 35,539, which the petitioner claims is entitled to on the basis of two work orders issued to the petitioner. Full stop. The respondent authorities have filed an affidavit in opposition, wherein it says that upon verification it was found that the petition, that though there was a completion certificate, but the supervisory reports so submitted were not adequate, in as much as neither they had any photographs nor their certain periods of supervision is missing. Full stop. An affidavit in reply has been filed by the petitioner thereupon. Full stop. This court inquired with the learned counsel appearing on behalf of the petitioner as to what is it the mandate of the tender conditions that there is a requirement of a supervision. And further, how the supervisors are appointed as per the tender conditions. The learned counsel submits that he would obtain instructions in that regard. This court also inquired with Mr. P. Nayak, the learned standing counsel of the GMC, as to whether there are specific appointment letters for the purpose of thereby appointing supervisors. Inasmuch as a perusal of the supervision reports which have been enclosed to the writ petition reveals that a concerned supervisor who gives the report has to carry out the supervision in respect to a very vast tract of area. In respect to one of such contract, it is the entire ward number 26. Whereas in respect to the other contract, it is the entire ward number 28 and 29. Mr. P. Nayak submits that he will also obtain instructions in that regard. List this matter again on, I've fairly heard it on that date, on, finish it on 8
January. Lots will take little later also.
Okay. On
After the, yes.
22nd? On 22nd at 2 p.m.
Your lordship,
On which date?
on 24th or 20th.
24.
24th you come. I'm not going to come. We are going to have working days on Saturday as has been taken. So we can have it
22nd,
on
I will
that
be out of-
24th.
22nd, I will be out of station. That's
Okay, on 29th
fine. Lord,
January 2025. 26. On which date? Mr. Pinack shall also produce the records of the case, or records relating to the verifications so carried out, as well as the tender papers, as well as the contracts which were entered into by and between the petitioner and the GMC authorities.
Respondent have filed an affidavit in opposition. I really need to file a reply,
The file reply?
I filed my reply.
but that is not record actually.
We filed it on 20th, I think. 26th we have filed, 26th November.
Hmm?
26th of November we have filed it. 26th.
Not filed. What do you want?
File a reply. By 19th
What
I-
reply again? Reply to reply, reply to reply. How much replies are there? There is an end to something, no?
By 19th, well, I will put everything, well, 19th. By 19th, I will file.
They filed it on 26th of November. We are in the December last week. There's no urgency.
The petitioner, my lord, they out of station. That's the petition. I will file.
It has been submitted that an affidavit in reply,
If it in opposition.
affidavit in opposition has been filed to the additional affidavit filed by the petitioner. The counsel appearing on behalf of the, have been filed on 26/11/2025. The counsel appearing on behalf of the petitioner seeks some accommodation for filing a reply. List the matter on 9th of March 2026. In the meantime, the reply be filed.
Order had been complied with, Manu. The demolition exercise had been done, Manu.
Order has been complied with.
Order. I think there is a report, my lord, with photographs. Last occasion I have submitted it.
What is the order passed?
What's will find in page number 17, my lord. Along with photograph, Manu. Though it is black and white, Manu.
What is this?
They said that particular illegal.
Mr.
that's
Counsel,
actually-
you have to give us better things. I know
Oh, sorry,
you
sorry.
are in bad
My lord, sorry,
shape.
but the original has been given, my lord, last occasion. This
You
is
are
from
in
my,
bad
this is
shape.
my.
I know
my-
that Sarva Six, what is that? GMC doesn't have money.
I'm sorry.
There's
my
no
lord, I-
quarrel
this
with
is
that.
My document, man.
You don't even have the money to print in a single page.
Sorry, my lord. I think there is a that document is on record, my lord, that photograph.
None appears on behalf of the petitioner on call. Full stop. It is also seen Mr. Esbora appears on behalf of the James, on behalf of the respondent and submitted that the order passed by this court dated
1/2/21.
1/2/2021 in WPC number 3390/2017 have been duly complied with. Full stop. Taking into account the above, the instant contempt proceeding stands dropped.
Okay.
Lordship, I'm appearing for that 26 number. I can put a contempt, and writ petition is being done by another set of counsels. 26. 27. 27. No, 28. 27.
Yes.
There is already a report by the circle officer.
What is the direction passed by this
The
court?
direction was not to continue with the further construction.
Are they
They are
constructing
page
now?
20. They have already completed.
Then
Second floor and third floor, Melo, during after.
where is the order?
Your
With
Honor,
Till returnable date, further construction of the building of the respondents shall not be permitted.
Yes.
Then
And they have constructed it. That pursuant to that, Melo, we filed this.
it is in your land.
Fine.
They have constructed.
And more so,
Have you filed a civil suit?
oh, the civil suit, there was a civil suit in that, there was a second appeal that was dismissed by your lordship only.
Whose second appeal?
Second appeal by them.
No. Have you filed a civil suit for demolition?
No, demolition, there is already an order, the writ petition, Melo, the connected writ petition. There is already an order of the GMC where they have directed for demolition. But despite that, there has been no action taken.
In which
Melo,
matter?
In the writ petition, 7421 of 2018,
Whose writ petition? Yours.
my writ petition. Page 50, Melo, will kindly see.
Page?
Page 50. 50.
This is given to whom?
This was the private respondent.
You are Alam.
He's
I am-
Islam.
I am Noor Islam.
I'm-
He is for Allah. He is
I'm for
Islam.
Alam.
Both are same, na?
No,
Brothers.
You are Alam, he is Islam.
I am Islam, he is Allah.
You are Islam, he is Alam.
He is Allah.
Okay. But the first two names are same.
First two names, sir.
Sheikh Noor.
Sheikh.
You are related.
They're brothers. sir.
Brothers.
They are brothers. By obtaining a fraudulent NOC, Miller, by way of a fraudulent NOC, he got an permission for construction of the building. That the division bench, thereafter the division bench passed an order declaring it to be a fraudulent NOC and the permission was directed to be cancelled. He filed a review petition that was also dismissed. After dismissal of the writ petition and the review petition, page 50 has been passed, the order by the CEO GMDA. Now,
Then-
despite this order is there, the GMDA has not acted upon this order. Therefore, I filed this writ petition. And in the writ petition, when the notice was issued, at that point of time, there was an interim order saying that there should not be any construction. At that point of time, it was up to first year. He has constructed.
So
second-
therefore, what is your suit for?
The suit was instituted by him, claiming declaration over the land solely by him. That was-
You did not file a suit. So therefore, you didn't also file a counterclaim. So therefore, if he has constructed anything out there, he may not have a right. You are not in possession.
Yes.
Are you not required to file a suit
For recovery.
for recovery and for demolition? Why you are filing all these things?
So
They may demolish, just for example, they may demolish. But as of now, do you have a right over the land?
was-
But Mr. Kaushik, tell me the basic fundamentals. You are not in possession, admittedly, because he is constructing. Where is your right? So your right has been already clouded when he is constructing. So are you not required to file a suit seeking declaration that you have a right? If you are to file a suit for declaring that you have a right, you also have to ask for recovery of possession and for demolishing of that construction. Why you are bringing the GMC unnecessary? Understood, all things are understood. But why you are drawing Mr. Esbora into the scene? Unnecessary.
Challenge in that repetition was
I think these Peters needs to be closed. You file a suit. Here, the fact remains, as of now, he has constructed two buildings, one 2-storied, one 3-story. Why you are not filing a suit? Or is it the mental satisfaction that at the end of the time they are going to demolish? They are demolishing, they will demolish, or they don't. You know the GMC and the GMDA, they say that whenever the matter is in some government land, we have no power. Whenever there is a civil dispute, we do not. So they have some restrictions, means they don't want to do so, isn't it? We take it as the stand of the GMDA, taking into account that you are not capable of demolishing. We'll take it as it is.
That camera will not go inside that setback area. There are practical difficulties that I have faced, madam, in some of the demolition.
So why you are not going inside? Take a, you don't need to take a bulldozer, take a big hammer out there and demolish some of the parts inside wherein you make it unstable.
And the hammer, what is called, don't know what that particular name is there, I can't see the legs.
You don't need the bulldozer to go there. You go there, bring a hammer, demolish it. Don't demolish the entire thing. Demolish those bathrooms out there where you can't use it thereafter.
Lordship, actually, during the course of these proceedings, when the RSA was also happening and this writ petition was also filed, in fact, there was a review petition. In that particular petition, Honorable High Court had passed an order. I have filed that affidavit in opposition.
Where?
That is in
In the contempt.
in the contempt.
Contempt or otherwise.
Just a minute.
in the contempt.
Yes, where?
In the
43.
43, yes. Page Annexure B. So there, this Honorable High Court, Division Bench had passed an order where page number 44 is the page number 44. The operational part starts here, my lord. If may I? Page number 44 of the affidavit in opposition in the contempt.
Yeah.
I will read the para. In inverted columns, it starts, Mr. Sheikh Nur Alam, a review petitioner, and Sheikh Nur Islam, respondent number 5. He was respondent number 5 at that time, are present in court in terms of order dated 2/6/2017. We have perused the order dated 2/6/2017 and have heard the learned counsel for the parties to get a feel of the subject matter of the dispute. After hearing the matter for some time, Mr. B. Ullah, learned counsel for the respondent 5, submits that his client is agreeable to sell the plot of land in question to the review petitioner as per government value. Mr. Sharma, learned counsel for the review petitioner, has agreed to this proposal and submits that once the quantum is arrived at, his client will pay to the respondent number 5 25% of the total amount arrived at. And in that way, this particular order was passed. And in fact, my client was ready to pay that 25% though. And then there was some compromise happening. So now also there may be some compromise between the still going on, but they have not yet come to a conclusion.
I'm not into this basis of compromise business. You can't use, both of you can't use this public law remedy
Absolutely.
in this regard.
Absolutely. Totally agree. Totally.
You go to the civil courts.
Yes.
Not if they don't demolish, you at the end of the day, you need to have a right. Your right has been clouded. You can't by way of a writ petition exercise all these things.
Examine the decree, my lord, by the
Huh?
court. The decree by the trial court, my lord. I am not aware about that.
Whose suit was it? His suit.
Yes, absolutely. Then that's where the appeal came.
Then unnecessary, this type of
I have
matters should not be there.
second appeal. Second, you were dismissed for on the ground of limitation.
Yes. So On merit, it has not.
Second appeal, first appeal, all these things, whose suit is his? His suit. You didn't have a counterclaim. Or did you file at any point of time a suit for recovery? Then it's a case of execution. Lekho, I think this is to be closed. And don't trouble Mr. S. Bora unnecessarily. He has better things to do.
Can it be immediately on reappeal? Let me go through.
No.
Well, I-
No.
What was the?
We
plea
need
for-
to finish it today itself. This type of matter should not go further.
That's
What do you
the-
say, Mr. Bora? Isn't there dispute between two? First two names are Sheikh Noor. Understood? Only the difference is one is a Noor and the other is an Islam. Then, what's the meaning of Noor? Beauty, if I'm not wrong. A Noor is what? Yes, counsel.
Yes.
Who is Noor?
I am Noor Alam. and
Okay,
he's
Noor.
Noor Islam.
Noor
Sheikh
Alam.
Noor.
Alam. You are one is Alam and the other is Islam. So, chalo, leho. Heard Mr. B. Kaushik, the learned counsel, appearing on behalf of the petitioner in the writ petition as well as in the contempt proceedings. This court have also heard Mr. So-and-so who represents the private respondent in private respondent. In both the writ petition as well as in the contempt application. I've also heard Mr. S. Bora, who represents the GMDA. The petitioner and the private respondent are both brothers. And there are inter-se disputes between both the between them as regards a particular plot of land wherein the private respondent have constructed two RCC buildings. The case of the petitioner in the writ petition is that the private respondent have constructed the building without having, on the basis of an fraudulent no objection certificate. On the basis of a no objection certificate fraudulently obtained. And this aspect was duly noted by this court in the earlier proceedings. And on the basis thereof, even the chief even the chief executive officer of the GMDA had issued an order dated 4/6/2018. The further grievance of the petitioner in the writ petition is that in spite of the order dated 4/6/2018, the GMDA authorities have not taken steps for demolition of the building of the private respondent. And it is under such circumstances the writ petition was filed. The record further reveals that on the day when the writ petition was moved, this court issued notice and further directed that till the returnable date, no further construction should be carried out in the building by the private respondent. It is relevant to take note of that in the order dated 12/10/2018, there was no returnable date fixed. And in fact, the direction was And in fact, the notice was issued making it returnable by 4 weeks. In the said writ petition, an affidavit in opposition has been filed by the private respondent, wherein the private respondent has claimed that he has right over the land in question. And there are disputes between the petitioner and the private respondent, for which the private respondent had filed a suit, which was dismissed, and thereupon a regular second appeal was pending before this court. It is further relevant to take note of that during the course of the hearing, the learned counsel appearing on behalf of the petitioner submitted that the said second appeal, being RSA number 65 of 2013, was dismissed by this court by an order dated 13 to 2025.
Yes,
25. Full stop. In the backdrop of the above, let this court now take note of as to why the contempt proceedings was initiated. Full stop. This court, while issuing the notice in the writ petition on 12/10/2018, directed that there shall be no further construction of the building of the respondent number 5. That directed that further construction of the building of the respondent number 5 shall not be permitted. In view of the said order, on the basis of the allegations that the respondent number 5 had carried out the construction, the contempt proceedings have been initiated, which is also listed before, have been initiated. This court have heard the learned counsels appearing on behalf of the parties. First, from the perusal of the materials on record, it therefore appears that the dispute between the petitioner and the private respondent is purely private disputes, civil and private disputes. And the petitioner have resorted to involving the public authorities as well as the public law remedy for redressal. It is also seen from the materials on record that the petitioner claims the private respondent is in possession of the land in question.
Jointly, the decree.
Then how is he constructing?
Jointly, the second floor and the third floor. Because there are other properties also in that plan. There were other properties, in fact, the suit was for partition, which was dismissed.
Are you saying that you are jointly in possession of a building which is being constructed on a land whereby why the GMC has to bring it?
No, because the permission which has been taken by them for construction of the RCC building of G+2 and G+3, showing our NOC, they have obtained the permission from the JMD.
Who has constructed the building?
The private respondent.
Who is in possession of that
No,
building?
half portion of the building we are also in possession.
You are in possession of the G2 and G3.
G1 and G, ground floor and the first floor.
Of that G2
G,
and G3.
G3, it is in the second, in the other portion of the land.
Are you in possession of the G3?
In the G3, we are not in.
So you are in possession of the G1, G2, where you are in possession of the ground floor and first floor. Now you want the demolition of the second floor
Second.
and the G3.
And because.
So the G3, you have no possession
G3 we have. What is that instruction?
from from the perusal of the materials on record, it therefore transpires that the dispute between the petitioner and the private respondent is purely a civil dispute. And the petitioner have not only involved the public authorities, but also invoke the public law remedy for redressal. During the course of the hearing, this court inquired with Mr. B. Kaushik, the learned counsel appearing on behalf of the petitioner, as to whether the petitioner is in possession of the two buildings, that is G+2 and G+3, over the land in question. The learned counsel appearing on behalf of the petitioner submitted that in respect to the G+2 building, the petitioner is in possession of the ground floor and the first floor. And the second floor has been constructed on the basis of a fraudulent NOC being issued purportedly by the petitioner. The learned counsel further submitted that as regards the G3 building, the petitioner is not in possession of the said building. It is the opinion of this court, that the said dispute being purely a civil dispute, the public law remedy cannot be permitted to be exercised for such redressal. More so, when the petitioner can very well file a suit before the competent court of civil jurisdiction, seeking declaration of its right, title, and interest, as well as for recovery of possession by demolishing any structures constructed thereupon. The learned counsel appearing on behalf of the petitioner, though submitted that a suit filed by the private respondent, which reached to the stage of the second appeal before this court has been dismissed. But the said dismissal of the second appeal or the suit filed by the private respondent would not, however, permit the petitioner to interfere unless there is a decree, save and except by following the due process of law, due procedure established by law. Considering the above, this court therefore is not inclined to entertain the instant writ petition, being WBC number 7421/2018. Insofar as the contempt application is concerned, there are disputed questions as to whether there was construction during that period when the interim order was in session. Considering the above, this court cannot come to a categorical finding that there has been willful and deliberate violation to the orders passed by this court. Consequently, the instant writ petition as well as the contempt application stands disposed of with the following observations and directions.
may I point out one thing? Page 36
Of,
of the affidavit filed by them in the contempt application. There's no denial to the construction memo. His contention is that he has no intention to disobey the court's order. He has not denied that he has constructed during the continuation of the interim order. His contention is that there was an interim order in the civil suit. There is an injunction in the civil suit. Pursuant to the dismissal of the second appeal, the injunction was not imposed. And therefore, he continued with the construction.
dispose of with the selling. First, number one, this court is not inclined to entertain the writ proceedings, being WPC number 7421/2018. However, it is observed, and accordingly, the writ petition stands dismissed. Number two, the dismissal of the writ petition, however, shall not preclude or prejudice the petitioner to avail remedies before the competent court of civil jurisdiction by filing appropriate suits seeking declaration as well as recovery of possession and demolition of structures by the private respondent, if so advised. Number 3. The contempt proceeding stands dropped. Number 4. The dropping of the instant contempt proceedings, however, shall not prejudice or, shall not prejudice the petitioner in any further proceedings so initiated against the respondent of the contempt proceedings. Mr. Kaushik, you should have advised. Next, the period during which the writ petition has been pending, that is, now this court duly takes note of that the petitioner herein have been diligently and bona fidely pursuing the present proceedings. And as such, the period from 9/10/2018 till date be excluded while computing the period of limitation. Otherwise, 7 years have gone.
Time.
Another 5 will be left.
Let them go. Let them go and appear and let them file a civil suit. That will help their cause.
No, we cannot look at it. In fact, Mr. Kaushik should have advised immediately that you should go and file or you should have gone for a civil suit while this matter was pending also.
Yes, absolutely.
And you could very well take up the GMC authorities later on, whatever may be, and take that document into account for demolition, which will help you. I think you should make the GMC also a party, GMDA.
Oblige, my lord. Oblige.
29 contempt.
Order has been complied, madam, so there is a complete ruling has been.
Mr. P. Mohanto, the learned counsel, appearing on behalf of the petitioner, submits that the order dated 11/5/2023 passed in WPC number 3071/2022 have been duly complied with. Considering the above, the instant contempt application accordingly stands dropped. Your junior came to mention this matter, but Mr. Mohanto, kindly appreciate one thing. If somebody else mentions it, and if I do it, I don't allow that practice out here for the reason that you may not do it in your case, but there might be in certain cases where this is being done later on, they come up and say that this person was never authorized. And then it will have a far-reaching consequences on that advocate's career.
Should we have filed a review in this case?
You have filed review?
Yes, Lordship.
Which one?
Item.
Non-payment?
Yes. Lordship.
Dismissed review?
Yes.
So then? Review has been dismissed.
Yes, Lordship.
Whatever may be, but you cannot comply, na?
Yes.
You come up with that stand. that you cannot comply unless the state is made a party.
Yes.
Have you taken actions in terms with these directions? You see, the directions which were being passed by the learned single judge, kindly come to this order, page 17. Within 15 days from today, the concerned official of the state government will communicate the supplementary budget passed in the last assembly pertaining to the scheme to the company of the so-and-so. Have you done this?
Yes, I think. Yes, I think.
Within 60 days from the date of the year, the Ministry of Jal Shakti to release the amount.
We have
Now the
communicated.
question is, here they have only asked you to release.
Yes, Lordship.
You cannot release it otherwise,
Yes, Lordship.
because they have not also approached the Ministry of Jal Shakti.
Yes, yes.
Can't help it. Very difficult.
Yes, Lordship.
None appears on behalf of the contemner on call. Ms. Tinglung, the learned counsel appearing on behalf of the water resource, on behalf of the respondent, submits that the instant contempt application cannot be permitted to be, cannot be proceeded with, inasmuch as the petitioner have not taken any steps insofar as the Ministry of Jal Shakti is concerned. Full The learning council submitted that in the instant case, comma, as per the order dated in the instant case, as per the order dated 27/9/2022, that this court have passed certain directions, which includes a direction to the Ministry of Jal Shakti to release. The Land Council further submits that without the Ministry of Jal Shakti releasing the amount, comma, the question of making any payment, the petitioner, the respondent herein cannot make any payment. She therefore submits that the instant contempt proceedings therefore ought to be dropped. This court have duly perused the order dated 27/9/2022 passed in WPC number 4734/2021, wherein the learned coordinate bench of this court had passed 3 directions. One of such directions is that the Ministry of Jal Shakti has to release the funds to the Water Resource Department of the Government of Assam. And then only the payment can be made to the writ petitioner. There is no allegations in the instant proceedings that the Ministry of Jal Shakti has released the said amount. Under such circumstances, comma, no case of contempt has been made out. No case of willful or deliberate violation to the order dated 27/9/2022 in WPC number 4734/2021 has been made out, for which the contempt proceeding stands dropped.
Obliged, Lordship. Same, Lordship, 31 to 33.
Same order. What? All same order.
Yes, Lordship.
Madam, you have been today successful in getting. No.
Same, Lordship. Deeply obliged.
Well, see, it was unlisted. Oh, it's a bench 5 matter. You got that? Permission tomorrow. Chalo. It's okay. Madam, in all these matters, they have only asked, they have not made the Ministry of Jal Shakti a party in the contempt. Any of the cases not made, na? Why you are the response number 5 then? What are the response numbers 1 to 4? You are the response number 5 or response number 1? Earlier I was seeing only one. Some I'll get some. Only one respondent. All the cases. Agute ki song. Here there are many more. এটা কাম কৰক এই দুটাত হ'ল we passed this order only in 30 and 31, madam. As regard 32 and 33, we adjourn the matter on some other day. Okay, not today, some other day. Okay, none appears on behalf 31, 32 and 33. Diog, none appears on behalf of the petitioner on call. Ms. So-and-so appears on behalf of all the respondents. তাৰপিছত লিখি দিবা we dispose it also, huh? All the respondents and submits that the order passed by this court dated so and so cannot be complied in the facts of the instant case in as much as the Ministry of Jal Shakti, without the release of money by the Ministry of Jal Shakti, whom directions have been issued specifically to release and thereupon to make payment, the question of there being any violation, willful or deliberate violation to the order passed by this court does not arise. We dispose of all.